The Mr. Whitney of FTI, who's assisted us with all of this, Your Honor, indicates in his headquarters is in San Francisco. The full videotape's in San Francisco. So he's put it on this laser disc, and it was flown down.
All right. Does the news organization have a second copy or the original copy here in Los Angeles, I assume?
I assume they would, but I'll have to call and ask. I'll try to find out, Your Honor.
See, Your Honor, the original is a videotape, and they've cut it and put it onto a laser disc.
I realize
Do you know
that.
about that?
Yes. Thank you.
Sorry.
She knows something
No,
about
that's,
everything.
that's, Ms. Clark, that's why I'm asking, where's the original? If it's one of the local news stations, perhaps we could get that messengered over here over the lunch hour. We could take a look at it, put it in context, and see what's there.
We can try, Your Honor.
See, the problem, Mr. Cochran, I have, though, this is a discovery issue, and the defense was entitled to know about, the prosecution was entitled to know about this.
Your Honor, the other side of that, and I think you can appreciate this, and having made a lot of opening statements yourself, you know the situation. We have things in our so-called arsenal. If you decide not to use it, that's their crime scene. You can understand it. So I'm not going to give them stuff that we're never going to use, Your Honor, and that's the question. We decided it, and so now we're making it available. And I understand what you're saying. We'll make an effort over the lunch hour to try and get that. The other one that we use is in San Francisco, so that means it'll be here by late tonight or tomorrow. But we'll try to find it over the lunch hour.
All right, counsel will stand in recess until 1:30.
Maybe approach this
Let me
one,
see
Jim.
counsel at the
Thank you.
sidebar without the
Approach this
reporter,
one.
please. All right, back on the record in the Simpson matter. Mr. Simpson is again present with counsel, Mr. Ullman, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, Mr. Hodgman. Mr. Cochran, what's the status of the videotape?
Your Honor, we have, excuse me, If the court pleases, we have a videotape that was delivered from my office. There's only one copy. This is not obviously the one that was in San Francisco. We've not had a chance to look at this one, and I just offered to Mr. Hodgman if we could get a VCR at some place. We'd look at it together and then maybe get a copy for them. And I cannot represent this has everything on it, but I know it certainly has part of it. That's certainly a start. We are also by some sort of express mail having the one from San Francisco delivered here. It'll be here this afternoon also.
So you're suggesting that we take a look to see if this is it, but we're not
Well,
certain?
I'm suggesting that we look at this one, and then we don't have to stop the proceedings while we do that. I'm suggesting that some members of the teams look at this, and then if this doesn't include everything that we're seeking to use in opening statement, the other one will be here hopefully this afternoon. And I'm advised that if it will be only one small item, if any, that's not on here. So perhaps we can look at it at some point.
And what small item might that be?
Mr. Blazer recalls from memory that there may be one scene with the two detectives walking that's not on here. That's maybe the one thing. But we need to be able to compare it, Your Honor. It was just delivered down here.
All right, what's the prosecution's response to this? Do we have the facilities with our system here to look at this videotape? All right, my technical advisors from Trial Presentations tells me we have the ability to look at the videotape here.
Your Honor, I'll be the spokesman for this issue. With regard to this, Your Honor, it still strikes me we have a couple problems. We have an authentication problem because what Mr. Cochran is saying is that this is their copy. They admit it's incomplete. Mr. Scheck informed me when I came down to court that this tape does not contain everything. So we need to know, one, is the tape that we ultimately view, is it properly authenticated? Is it everything they have? And then secondly...
Hold on, let me
yes.
jump ahead. What's the running time of this tape, Mr. Scheck, or Mr. Glazer?
I think it's about 20 to 25 minutes, and I just fast-forward through it and to see if everything was on there. I think everything may be on there. There may be one short clip that was missing. I just looked through it very quickly so I could get down here with it.
All right.
Mr. Blazer, for the record.
All right. Counsel, I think we'd spend 20 minutes arguing about it. Why don't let's just take a look and see what's there? I'm sorry?
Your Honor, if I may. Mr. Blazier, is this tape a compilation of different taped segments? Would you answer that for me?
I think it might be. I believe it's CNN outtakes, and I think this is the form that we got it in. We haven't done anything to it, so this is the form that we got it in, I believe.
Your Honor, I went to San Francisco twice and helped edit this tape. It is a compilation.
Well, the stuff on the laser disc is a compilation. I don't think the tape is.
Then the question is, Your Honor, a compilation from which sources? This just compounds.
Mr. Hodgman, if they can't tell me what it is exactly yet, I've heard slightly conflicting things. Let's just take a quick look at it. Let's run it for 5 minutes. If it appears to be compilations of things, then I agree, we got a foundation problem. But let's see what it is, rather than spend the next 20 minutes arguing about it. All right, can Trial Presentations play this tape for me?
Videotape player is on the cart. Any of counsel table can put it in and play it for you, Your Honor.
All right.
Mr. Bailey, directly behind you, and this gentleman sitting behind the elbow. He can plug it in.
Let me ask Mr. Glazer. Mr. Glazer, are there any actual depictions of the victims' bodies during the course of this videotape?
I'm not sure, Judge. There may be a very short clip of that. Actually, there is a clip on there, Your Honor.
There is?
Yes. There may be a couple, actually. An approach.
All right. That at this point. But yes, we'll leave. Madam Clerk, let's have the, when submitted, not a photocopy, a dub of this videotape as Court's Exhibit next in order 2 for this hearing. All right, Mr. Cochran, what's the latest on the San Francisco?
Mr. Whitney indicates there is a tape in San Francisco. He also believes there may be one other tape with the missing scenes back at the office. And if the court would allow him, it would save some time. He'll go back to the office now and try to see if he can find it and queue it up and try to come back and find that if he can.
All right. Well,
he knows what to look for.
Before you rush off to do that, let me tell you what this tells me. Given what appears now to be various sources for these different video outtakes, this appears to be a montage of video pictures from different sources that I'm not persuaded that we have a adequate foundation as far as time is concerned.
Well, I'd like to be heard at the appropriate time.
Well, now's the time.
All right, Your Honor, what I would indicate on that is this, that first of all, the court can see from there's a lot of material on the tape that we have here which would be basically irrelevant material. So what happened is we took the parts that we thought were appropriate. It's an accurate, true copy, as you could see. What we're trying to do is give the court the accurate and true copies taken by news organizations of what happened contemporaneously with the event. And so I think clearly, what I've always argued, this is admissible from a standpoint of showing what happened. If we wanted to argue that certain things were shown in these photographs with regard to the collection of evidence by the Los Angeles Police Department, its representatives, and the coroner's office. So what I've argued from this morning is that it seems to me that becomes a question not of admissibility, but of weight. And it seems that Ms. Clark had an objection this morning that we couldn't determine when these things were done and when they were taken. Well, you will notice on the tape that was shown this afternoon, the individuals were being logged in as they came in. We can look at the log and determine the time. We know what time the coroners got there, so we know what time the bodies were taken away and that sort of thing. And I think what we were trying to demonstrate on these tapes was the collection procedures, as the court rightly said this morning. Now, it would be nice if all that was on one group of tapes, but apparently that's not so, and we'd like an opportunity to show you the other tape. And these are not anything that we in any way have changed around or whatever. We're just trying to demonstrate at that scene on June 13th, while Detectives Van Adder and Lang and Detective Rogers was at that scene, these things took place. So that I think that from laying a foundation, clearly we can pinpoint and fix the time, it seems.
But the problem with this videotape is obviously starts and stops. It takes I recall at least 3 different vantage points. So obviously the tape had to stop, then the camera person had to move to another location, start their film again. So we have no idea in what time sequence these things happened.
But, Your Honor,
And Mr. Cochran, let me tell you the other thing that concerns me, and perhaps you can address your remarks to this. These videotapes were generated June the 13th, and I don't know how long that you have had these in your possession, but clearly the evidence collection process has been a major focus of the defense all along. I think we all agree with that. It was your obligation to put together this item and show it to the prosecution in a timely manner, which has not occurred. So my inclination at this point is, since the prosecution raises the objection, my inclination is to rule that you cannot use this videotape montage in the course of your opening statements, and you may not use it until you've shown these videotapes to the people. I also am not going to grant their motion to continue.
I like the last part. Let me address just the first part just briefly.
Right.
Your Honor, as the court knows, the court maybe has never been a defense lawyer.
I have,
Okay,
counsel.
well, then you will understand this clearly, I think. Your Honor, in this situation, and I'm very mindful of Proposition 115, but as the court knows, a defendant in a criminal case doesn't have to prove anything. And you've said that to the jurors, and that's what the laws are. In this case, we want to anticipate many things that the prosecution is going to do and argue and that sort of thing. So our job, from the very beginning in defending this man, is to gather as much evidence as we can. Your Honor, there's no obligation, it seems to me, if we got that tape or it came into our possession, let's say in August, to share it at that time with the prosecution. I don't know what the issues are going to be. At such time as we now know where we're going, what their theory is, they said to you in this court last week, for the 5th time we're going to change our strategy or change our theory. Your court recalled that byplay with Mr. Darden. Now let's assume now they finally settle on something they want to go forward with. Now, that means we now have to say, okay, guys, let's get geared up. Let's go back and do it. If that thought in mind, we then try to put this together. So I'm trying to...
Mr. Cochran, that part of your defense and that part of their case has never changed. They have always wanted to present forensic evidence regarding what was collected at the crime scene, and you've always wanted to attack the process and the integrity and the reliability of that evidence. That hasn't changed.
That has not changed, Your Honor. However, how we attack and what we do with it, may change. As you can appreciate, there was a lot of soul searching with regard to the DNA hearing and how we would look at that and that sort of thing. This evidence helped us through that particular part of it. But at some point, we had to make a position that, okay, now here's where we want to go forward, and that's what we did. Now, I just want to make sure the court understands our thinking from that standpoint. Judge, this is not any big surprise. This is their crime scene, Judge. The witnesses depicted in the crime scene are these gentlemen seated here. This is their case. And so we just have pictures of what they were doing. So I don't see that they're surprised or in any way they're prejudiced. As always, we want to share with them what we have at the appropriate time. And I think reasonable minds can differ at what point the defense has to reveal these things, because this isn't like any big surprise to the prosecution. They're the ones out there doing these things.
Well, Mr. Cochran, here's the problem, though. We all agreed on a schedule, and your client, as is his right, has insisted on going to trial at the earliest possible date, and we've honored that request. We originally had our opening statement scheduled for last Thursday. And these exhibits are just now being put together, so I think there's significant delay on the defense part in getting this thing together.
Well, I think what would happen is, let me just abide with me for a moment, Your Honor. If we had the opening statements on Thursday, then this argument that we're having today would have been Wednesday. I mean, I think that's what I'm saying to Your Honor. And I understand your position in the matter. I mean, with regard to turning over things from the defense, Your Honor, they are not in a position where we need to help them with their case. This is their crime scene, Judge.
I agree.
And the law doesn't, I don't think the law's gone that far where they make us do that. So what I'm saying is, in this instance, how can they stand here in good conscience and say to you, we're surprised by this crime scene? Now, I can understand your argument, your statement with regard to the montage, but how can they say they're surprised by their own crime scene? They've got all the witnesses here.
Mr. Cochran, here we are. We're scheduled to begin our opening statements today. And as I have said, I don't feel any pressure to have to start today. I could start tomorrow, I could start next month. It doesn't make any difference to me. But we did have it scheduled. We don't even have the complete set of videotapes that comprise this montage of video scenes, so we can't even proceed at this point to determine whether or not the prosecution's objection is valid. So my inclination at this point is to say, if you want to proceed today, proceed without the videotape.
All right, let me just suggest one thing to you. Mr. Whitney said he would go back to the office. That'll take about 20 minutes. If the court would allow him then to call back and see if he's able to find something else, at least we'll get the balance of the tape, and then we have other motions at this point at any rate, so we'll not lose time. Would the court allow us that?
All right, have your staff do that.
All right, we'll do that, and then I will get back to the court as soon as he's back at the office, and then we can then conclude this matter. That's all right.
All right.
All right, thank you, Your Honor.
We have a few more matters to conclude as well. All right, then we will put the use of the videotape on hold till we find out the existence, whereabouts of the second or third videotape. All right, Mr. Douglas, I have here a motion, ex parte motion, the 3-page motion. Do you want to address that now? Mr. Cochran, do you want to address the... Sure.
No, it's no longer ex parte now.
Well,
It's not ex parte, it's filed under seal, I guess, basically. It's just issued.
all right, my copy of the motion indicates a copy was served on the prosecution.
No, that's a mistake. It was not. It was not.
All right, then,
No.
why don't you share it with
Yeah.
Mr. Hodgman and Ms.
This was
Clark?
just filed this morning, so nobody's.
I understand the press was given a copy of it, however.
Not by us.
Yes, by you.
No, no.
No, by the court,
By the court.
by the court.
People have never seen it.
Well, Ms. Clark, when I looked at the, forgive me, but when I looked at the motion, there's a proof of service that indicates it was served January 20. Now, whether, see, I have to rely on that.
Yeah, I agree with you.
All right. Before you start castigating me.
No, no,
All right.
no, people would never.
It's okay, Your Honor. You can get in line, Your Honor. It's okay today. You'll be in good company, however.
It's part of the job. All right, Mr. Cochran, do you want to address your motion? All right. Yes.
Your Honor, what happened is, I understand this morning, this motion was filed by Ms. Sean Snyder, chaplain of our office, and we sought to file it under seal because of security concerns, and apparently the prosecution was not giving one that says ex parte and filed under seal on the motion. I think it was handed to Your Honor's clerk. It was then apparently...
Excuse me, Mr. Hodgman, Ms. Clark, do you actually have a physical copy of this?
Okay.
I have one extra.
And they have not been given one. As I understand the sequence of events, the court felt it was not a proper motion for ex parte. It was released to the press. because we went down at lunchtime.
So I
was asking about it.
assumed it was not ex parte because your proof of service on the
Yeah.
back indicates that it was served on the prosecution.
Anyway, but it says under seal. We thought it was under seal, but the press had asked me about it. Quite simply, what we're seeking here is based upon some security concerns, Your Honor, Mr. Simpson being in custody. We asked the court if, number one, Mr. Simpson could participate by giving a brief portion of the opening statement. And two, that during the course of the balance of the opening statement, there may be times, and will probably be times, when I'd like Mr. Simpson to be able to approach the jury to demonstrate certain things that I think are very relevant in the course of that opening statement. The only way that we could appropriately discuss this, and the latter part has nothing to do with the people, would be to clear that with Your Honor and Your Honor's bailiff, and that's the thought in which this was done.
All right. Mr. Hodgman, do you want to respond to these two issues?
Ms. Clark would like to address the
I'll
court.
address this briefly, Your Honor. First of all, let me indicate that their failure to serve us is further indication of the defense attempt to have this be a trial by ambush. We should have been apprised of this motion long ago, and their failure to serve us is, I think, an egregious act on their part. Furthermore, what this is really is just an attempt to ask the court's leave to allow the defendant to testify without being cross-examined. And there is no such right, I don't think, anywhere in the country in opening statement, or perhaps even in the world. There is no authority cited in this motion, and of course there could not be, because there is no law, there is no case, nor has there ever been a case in which such a thing has been allowed under the circumstances proposed by counsel. If Mr. Simpson would like to testify, we'd be delighted to cross-examine him and to hear his testimony at the appropriate time. But counsel's motion is simply an effort to have him present testimony to the jury without being cross-examined, and there is nothing that allows him to do so under the law. May I have a motion, Your Honor? I would parenthetically add also, Your Honor, that there's, what is the reliability of having Mr. Simpson today demonstrate for us his physical limitations? That would not, if he indeed has any physical limitations today, how does that bear on what his capabilities were on June the 12th? There is no bearing. And simply allowing him to get up and do physical demonstrations without being cross-examined, without us allowing us to have a doctor examine him to determine what his status is today versus what it was then, there's just no reliability to the demonstration proffered by counsel. So I would indicate for all of the above reasons, I can't see how this could ever be permissible, how this could ever be a proper thing to do, and people respectfully request the court to deny this request.
Well, isn't it oftentimes commonplace in our trial courts for defendants to exhibit certain tattoos or physical marks or something about their person that is non-testimonial?
When they have foundational showing to back it up, pursuant to testimony, for example, if they have a defendant who has a tattoo that was not described by an identification witness, that would be appropriate if he could lay the foundation that he had the tattoo back on the date in question. But we're not at the point of taking testimony, Your Honor. We're not in the trial. We're not taking evidence. This is an opening statement. This is a request to take evidence in the opening statement, and that's not permissible. And there's no foundation that they're going to lay with respect to evidentiary foundations in the opening statement. It's just argument.
Mr. Cochran, what's the nature of the exhibition that you're contemplating?
And may I also indicate that he's also proposing to do an introductory statement to the jury. That's another request to take evidence, to testify before the jury without being cross-examined. There's no reliability to what the defense offers to do in this case, in this request, with respect to their proffer of physical limitations. And it's basically asking for a right of allocution. All of what and everything that they want to demonstrate to the jury could be done through photographs, and is going to be done, as I understand it from what I've seen, through photographs. So that would be much more relevant than what the defendant looks like today. Yeah. I'm not saying that, I'm not conceding that they are relevant, but at least they're closer in time to the events in question than we are today, and I can't see what the relevance is of any of it.
May I answer your question now?
Briefly. Yes, thank you.
This is my time, Your Honor. With regard to this, first of all, the fact that counsel's never heard of a defendant Giving an opening statement doesn't mean that hasn't happened. It has, in fact, happened in the past. The court has indicated to us that 2 lawyers or 2 persons from each side could, in fact, give statements. We'll start with that exact point. And Mr. Simpson has been made aware of the limitations of the opening statement. The court will instruct the jurors that what Ms. Clark says in an opening statement, what Mr. Darden says in an opening statement, is not evidence. And so we're not trying to preclude them. It seems like they're always trying to preclude us from doing something, Your Honor. And then they talk about in the search for the truth. What I've asked, and I spelled it out quite clearly, is Mr. Simpson understands the rules of evidence from that standpoint. I think he has a right to do that, and they have no case saying he can't do that. The other point is that they're not even involved in that. It seems it happens all the time. And she's working about foundational aspect, Your Honor. As an officer of this court, if Mr. Simpson approaches the jury, and let's assume arguendo that he shows the jury some scars on his arm, that he can't raise his arm above a certain limit. I think the court could understand clearly. I wouldn't ask that to be shown if those scars didn't come from the time he played football or something like that. If he has some physical limitations, clearly we're talking about physical limitations that existed long before June 12th of 1994. So again, Your Honor, everything that comes up, they want to know everything that we know. Certain things, Your Honor, they're not entitled to know. They brought this case. They made this decision, Your Honor, and they have to live with some of these things. And so what we did this morning was to try and put it before Your Honor, which is the proper place. These are matters of security more than anything else, and you're the one who makes that decision. And so that's what we were seeking to do.
All right, would you give me a little more explanation as to exactly what type of demonstration of your client's physique that you wish to be made?
The court wants me to be body specific?
Yes. What do we, I mean, what's relevant to this case that the jury needs to see at this point? And how does that differ from a presentation of evidence during the course of the opening statement?
I'd like to do that, and I'd rather do it at sidebar if I can.
Sure. All right, thank you, counsel. The record should reflect the court has heard at sidebar the offer of proof as to the nature of the demonstration that would be made. Prosecution has asked for an opportunity to respond to this motion since this was they just became aware of it late this morning. It seems to me, by looking at the clock today, that we will not get to the defense part of the opening statement today. So I'll give counsel for the prosecution leave until tomorrow morning to raise any objections to the suggestion made by the defense.
Yeah, we appreciate that. The problem is that how can we proceed with opening statements ourselves without knowing what the defense is going to be permitted to do? The defense complains about we're always asking to preclude them from doing something. We're not. We're asking for a fair and orderly trial in which the people's rights are not being abrogated by these last-minute ambushes, where they're making requests. Now that they've made a motion that we've never seen before, and they want us to be able to respond immediately to it. The court's giving us until tomorrow, and we appreciate that, but we certainly cannot plan our strategy without knowing how the ruling is going to go. This impacts on us, and I think that counsel's admission...
Counsel, you're aware that when defendants make presentations that are testimonial in nature, they're subject to cross-examination. That seems to be pretty well settled. Mm-hmm. You're also normally it's the prosecution that's here asking for non-testimonial evidence to be presented, such as physiques, physical injury, that sort of thing, as being non-testimonial.
But that's during a trial, Your Honor. This is opening statement.
I understand
this is not
that,
the time for the admission of evidence, and that's the problem we have.
Well, counsel, what's the difference between your showing photographs of one of the victim's bodies and the demonstration that's suggested by Mr. Cochran? What's the difference? They're both presentation of what will probably be evidence at trial. The issue is there something that's going to be fundamentally unfair about it?
Yeah. What is the difference? What the difference is that...
Well, counsel, I've already told you I'll hear the argument tomorrow morning. I'm giving you leave till tomorrow morning.
Okay. I can only reiterate that...
No, you don't need to reiterate if I've already heard it.
Well, you haven't heard this.
As soon as you say I want to reiterate.
You're right. I used the wrong word.
All right.
Counsel, as the court is aware, counsel already has photographs of the injury that they've shown me, and they can take more tonight.
You're arguing the motion now. I've said I'll hear the argument tomorrow morning.
Very
If
well,
you
Your
want to
Honor.
raise it again, it's not a big deal at this point.
All right. All I'm asking, I won't address it any further.
Thank you.
All I was asking was that the court give us an opportunity to know the ruling before we argue, before we give opening statement, before the people give opening statement. The court's aware of that request.
Did you hear what I said about 2 minutes ago?
I'm sure I heard everything the court said.
Okay. Okay, let me take a deep breath here. All right, Mr. Cochran, have we received any word from your office regarding the whereabouts of the second or third videotapes?
No, Your Honor, I expected it would take them about 20 minutes. We're a little short of that. They're going to call the clerk as soon as they get to the office, and then I'll let Your Honor know as soon as we get word.
All right, then let's take up then the defense proffer of evidence regarding the impeachment of Detective Furman. Mr. Bailey.
To please the court, in your ruling, you suggested that there was clear relevance in view of the fact that Detective Furman had confronted Mr. Simpson and his then either fiancee or wife in 1985.
A very unique set of circumstances here.
Right. And the question was whether or not there was some proffer of evidence that would make his bias relevant, since the bias was inherent in his statement. We have given you several examples.
No, Mr. Bailey, maybe I failed to communicate the import of my ruling. What I'm indicating to you, that it's an unusual factual situation that you have a detective who had contact with both the victim and the defendant in 1985, then crosses paths with them again in 1989, and then crosses paths with them again on June the 12th or 13th of 1994. That's unusual. Then you have the proffered statement of Kathleen Bell, which touches on racial bias, disapproval of interracial couples, and willingness to fabricate probable cause. So I agree it's relevant. I agree it's relevant to the issue of racial animus. It's relevant to the issue of willingness to fabricate probable cause. It's relevant to racial prejudice as well. The issue then becomes, once we have that, how do we get to how it's relevant to this case, given the detective's activities on this case? That's the question that I have.
Let me start at a fundamental
In
point.
other words, how do I make that bridge from this to what you were attempting to prove regarding Detective Furman?
Against the frustrations of our earlier excursions, Your Honor, this task is lifted from your shoulders by the United States Supreme Court in the Second District, who have clearly ruled that to eliminate any questions on cross-examination of a relevant witness for the prosecution relating to his racial bias against a person or a race of which he is a member would be fundamental constitutional error per se with no discretion. So if you start from that point and then assume, as I think you should based on the facts in this case, that without Detective Furman there is no possible way to get into evidence that glove, claimed to match the one found at the scene, claimed to have the blood of the murder victims on it, which allegedly was located by Furman in an alley between a chain-link fence and the defendant's house on his premises on the morning of the 13th, you anticipate that Detective Furman will be a witness. We are entitled to attack the credibility of any witness whose testimony tends to incriminate the accused. In addition to that, we have told you in our papers, and perhaps for the first time, that Detective Furman then went on within hours to suppress vital evidence tending to exculpate the defendant, because he interviewed and asked questions of one Rosa Lopez, who lives next door, who saw the defendant's Bronco at its parking spot on Rockingham between 10:15 and 10:20 that night. He reported it to no one. There are no reports about it, and she has never been interviewed by the prosecution as of last night. So if he suppressed evidence and claimed to find incriminating evidence, I think we hardly need go further before we have the right to ask him, and by the way, haven't you said on past occasions that you are in favor of genocide? Because what he really said was, let's put them all in a pile and burn them all. And I haven't heard that come from anyone since Adolf Hitler. That's a pretty extreme statement. Not only that, Mr. Furman, as of this morning, invoked the jurisdiction of Good Morning America to make public and truculent statement about the trial plans and ammunition of my colleagues from the prosecution as to how they will decimate the witness who claims she heard him say these things after she tried to fix him up with a woman who had gone out with a black man. This was an outburst. So I cannot imagine a clearer case of the defense having an absolute and inalienable, indelible, irrevocable right to smash into any person so low-life as to make those utterances and then proceed to the witness stand and attempt to incriminate for murder through these defalcations and spoliation a member of the African-American race. There could be no clearer case, but the Anthony case, Your Honor, it seems to me, makes it very clear to the court that any elimination or limitation, because in Anthony, one racial bias question was allowed, the second one was excluded. And that was held to be a violation, not of California, but of the United States Constitution, relying on Davis v. Alaska, a 1974 case in which Chief Justice Berger, joined by 6 other justices, condemned any limitation on racial bias questions on cross-examination. I don't see any wiggling room, and while I was happy to put together the proffer that you asked for in your ruling, Your Honor, simply because you asked for it, I don't think it was necessary. I think once Furman hits the stand without any warning to anybody as to what we're up to, we're able to ask him, don't you hate black people? And haven't you said so on many occasions, and particularly this occasion, after you learned that this defendant had a romantic entanglement with a Caucasian woman? I believe that crosses the bridge, and I believe it crosses it in such a way that it can never be torn down. I think beyond the Anthony case, there's nowhere else to look. Certainly, this is an area carved out where judicial discretion has been pinched down to the point where it may not exist, except in cases of rank abuse, when there was no possible relevance to the person's bias as it related to his testimony. But the bias of this witness against this defendant in particular, and his race in general, could well explain a number of false statements on his part, which we're going to tell the jury he's made. We're not trying to prove that he planted anything, because we don't have to. We're simply saying, if the only evidence you have that this glove came from O.J. Simpson's home is Detective Mark Furman, that isn't enough evidence to convict a rat, let alone a human being. And I think that's a fair argument under the circumstances of this case. After all, there's another principle at play here, if it please the court. This is the people's witness. The people are estopped to complain that, having been put on notice in 1981 that this fellow had terrible racist feelings, terrible feelings he couldn't control his violence against people he was arrested, they found that he not only was good enough to stay on as an LAPD detective, but promoted him in the process. And certainly if Mrs. Bell was hearing his racist feelings in 1985 or 1986, someone in the department was hearing it, and they were terribly insensitive to leave him with a badge and a gun, knowing how he felt in this city and the turmoil it suffered. Does the court have any questions as to the proffer?
Not at this point, Counsel.
Thank you.
Ms. Lewis?
Good afternoon, Your Honor. I was impressed by Mr. Bailey's drama and emphasis and finger-pointing, but that does not take the place of an offer of proof, of evidence, which is what this court ruled was required. Mr. Bailey also just now apparently was seeking to relitigate the motion itself, and that was totally inappropriate. The offer of proof that the defense gives the court within their motion is proof of speculation. There is simply nothing in here. Further, they go beyond, and they now are claiming that the Bronco was moved because of inconsistent testimony early on at the preliminary hearing that the defendant's Ford Bronco is moved. This is a brand-new allegation arising out of whole cloth, out of defense speculation, out of the dream of the defense team that something could come up to divert the jury's attention in a very serious way. The court saw the demonstration, I shouldn't say demonstration, but the effect of the racial argument as it happens, when it came out through Mr. Darden for the prosecution and Mr. Cochran for the defense. The court saw for itself how very inflammatory that gets very easily. The court ruled in these areas, ruled under 352 that the 1981 lawsuit was too remote to be reasonably relevant here, that the Joseph Britton matter was too remote to be reasonably relevant here. The court had appeared
No, I
to...
said the Britton matter was speculative because there was no direct evidence of any misconduct or any expression of racial animus.
Thank you.
Not that it was remote.
Thank you. And I overstated it when I said that it was too remote to be relevant, since it was purely speculation and there was no evidence to back that either. But in this situation, the court's ruling was absolutely clear to me, having read it. It was detailed in 5 pages. And what was clear is that the defense, 4.5. What was clear is that the court was requiring of the defense some offer of evidence that this detective moved evidence, whether it be the glove or any other evidence.
But the argument has changed and shifted. The argument is now gone. See, the interesting thing is the way this all played out, because it started out as a motion in limine by the prosecution to limit this. So essentially, you framed the issue as you wanted it, which was the allegation published in a magazine back east that Detective Furman had planted the evidence. So that was the point of your offensive in this case. The response that I got this morning from the defense is that they are, under any circumstance, entitled to cross-examine as to racial animus, and they cite 2 cases that appear to be controlling.
I'm not aware of the second case. Of course, they cited the Anthony P. case, which I, as an officer of the court, brought to the court's attention because they weren't even able to locate that during their earlier response. The Anthony P. case, Your Honor, I believe is distinguishable here. In that case, if the court recalls, all the defense tried to do was to cross-examine in that one area, and that was it. Apparently, there were no other avenues open to the defense. And that's because, as the court said on page 506 comes to mind of that case, in Ray Anthony P., that the entire case rested entirely on the credibility of the complaining victim, who was the victim of what factually appeared to be a sexual battery. So there was no corroboration, no physical evidence to corroborate, no other witnesses who saw the event or even saw her run from the event. And when you had a one-on-one credibility contest, the Anthony P. court felt it was appropriate to allow that. The situation we have here is vastly different. We have an abundant evidence other than the glove at Rockingham, which the court is aware of and will hear more of as time goes by and as the trial evolves, and certainly by the time opening statements are completed. But this is not a situation where this is the sole witness, the victim, complaining witness. This is not a situation where we have the whole credibility of the entire case and the entire basis of every element of the charges in that case, where all of that is coming from the mouth of one person testifying from the witness stand. This is a case where, as the court knows, there's going to be, I don't want to say hundreds, but there's going to be lots and lots of witnesses going to various different types of evidence. And the 352 analysis still applies here, that it is something that requires deep consideration. And it does not behoove the court to allow the defense to recast the true framework of Detective Furman's testimony in trying to turn it into a credibility contest as if he were indeed as if his credibility were at stake in the same way that it was for that complaining victim and sole witness in the Anthony P. case. They're trying to twist the facts of this case to fit that, but in reality they don't. This case is not that case. Now, the court mentioned a second case they cited in support of, and I'm not sure, they do cite, along with Anthony P., which we provided the court with, Larry E. versus Superior Court. That case had to do with a Pitchess motion, and the prosecution there had argued that the personnel records of a police officer not named as a victim in the complaint should not be discoverable, and the Court of Appeal, I believe it was, held otherwise. That was for purposes of a Pitchess motion, which, as the court is well aware, a Pitchess motion goes to discovery, and the only ground for discovery, or the only requirement, is that it be reasonably likely to lead to admissible evidence. But even in this case itself, I think the court in here notes that they're not talking about evidence that would be admissible at trial. They're talking about simply a discovery matter. And in this case, the court indeed did review the personnel documents that were provided to it, and I believe Mark Furman's attorney requested the court do that. The court did it, so in a limited respect, it looked into the matter, determined there was nothing relevant in those records, and indeed, there was not. And the bottom line, Your Honor, is that it would be inappropriate to allow the defense to go on a fishing expedition, raising an inflammatory issue of racial animosity in front of the jury when there is no evidence to support that nexus, to provide that nexus to begin with. And we do dovetail back into the third-party culpability case law, which requires some evidentiary link prior to there being any relevance to motive or opportunity evidence. So they have failed to come forth with that, Your Honor. And Mr. Bailey, though he may be eloquent and perhaps persuasive to a trier of fact, certainly should not be persuasive to this court, because the court has behind it all of the law and all of the facts in this area, and the court has done a very careful and reasoned analysis, and I certainly appreciated the carefulness and the ruling which the court came forth with, which showed that the court had carefully thought out the issue. And the defense has simply failed to do what the court decided it would allow, and that would be a last-minute offer. If they had some true evidence, let them come forward with it. It's sort of put up or shut up. And the defense, frankly, has not done that. They have not put up, so they should shut up.
All right, thank you, counsel. Mr. Bailey?
I should just explain, Your Honor, that the other juvenile case we cited was in response to their claim that they're not going to ask Detective Furman any questions about the 1985 incident, which was obviously an effort to protect him from cross about that incident. The second case says you can't do that. You can't pull an officer back once he was involved, say you're not going to testify, and then protect him from discovery and other remedies. And as to the latter remark of counsel, we're always told we're on a fishing expedition. If ever there was a case where an 1,800-pound marlin was hooked, gaffed, and in the boat, this is such a case.
Thank you, counsel. All right, as to Detective Furman, I'm going to preclude the defense from pursuing that line during the course of opening statements for this reason. Because of the turning over today of other statements made by Kathleen Bell, who is the genesis of this particular issue. However, after the prosecution has had the opportunity to re-interview or re-examine those statements, I will allow cross-examination on that issue.
Thank you very much, sir.
All right.
Your Honor, so that the record is clear, when you said you're going to allow cross-examination on that issue, is that on the issue of racial bias or animus as a whole, or on the 1985 incident?
Racial bias as to the statement by Kathleen Bell as it relates to this particular case.
You know, I don't want to be the policeman of the group, but if we're going to have a one lawyer, one issue rule, I
That's
thought it was
true.
to start at 1:30.
Well, in that case, I would like to make sure that I understand the ruling as well,
Yes.
Your Honor, and that is that the defense,
I am precluding the defense from making mention of Detective Furman during the course of their opening statement solely on the basis of the fact of the late turning over of the other statements of Kathleen Bell today. However, I find the issue of racial animosity to be something that they're entitled to cross-examine on.
and Your Honor, that still does not quite conclude the court's ruling with regard to Kathleen Bell in terms of the 352 aspect of its remoteness.
No, I don't find it to be remote. I think I already ruled on that particular issue.
So the court is satisfied that the defense came up with an offer of proof, or the court is concerned, frankly, about In re Anthony P?
No, we've switched, the theory here on the defense side changed. It's no longer an issue of planting evidence, it's the right to cross-examine on racial animus. See, that's the interesting thing about how this whole thing developed. It developed as a prosecution motion in limine. Normally, it's the other way around.
Your Honor, how is racial animosity?
Counsel, I'm not gonna hear it again. I've ruled, my ruling's in the record. It should be clear at this point. Thank you. All right.
Your Honor, back, Your Honor, with the tapes. I asked them to come right back immediately. They should be here very shortly.
All right, while we're waiting for that, then, council, I have issued an order regarding courtroom conduct. Have council received a copy of this, Mrs. Robertson? All right, would you make a half dozen copies for each side, please? All right. All right, counsel, I appreciate if you would discuss the court's order with any partisans on either side. Court will not tolerate any exhibitions of opinion or reaction to any of the witnesses or evidence that is presented. There will be no talking in the audience while court is in session. Bailiffs are authorized to remove any person that they see talking in the courtroom while court is in session. Court will not allow any symbols or statements supporting either side, such as T-shirts, buttons, or other visible forms of support or communication. Attempts to communicate with members of the jury are, of course, strictly prohibited. All electronic devices, such as telephones, pagers, and alarm watches, shall be turned off while in the courtroom. Any device going off, the sheriffs are to confiscate. Any questions?
No, we've read it from our standpoint. We'll make sure that each member of the
All right. Any questions from the people?
No questions. We will distribute this to the prosecution side as well.
All right, thank you. All right, counsel, while we're waiting, let me tell you the ground rules of our trial when we actually, if and when we ever get started. One lawyer addresses the court per side, per objection, per issue. There will be no exceptions to this. You may take time if you wish to consult with your colleagues. Court will be generous in granting you leave to do that. There will be no speaking objections. Objections will be handled at the sidebar as is appropriate. Also, we will begin promptly on time each day, every day. That means that at 9 o'clock, everybody is in their place and ready to go, not that they're wandering in at 9 o'clock. We will be starting at 9 o'clock, and we will starting at 1:30. And there will be no exceptions to that rule. All right, counsel, anything else we need to discuss before the videotape shows up?
one thing if I might.
Yes.
We from the defense would ask the court to consider. We certainly subscribe to the rules that Your Honor set forth. In the first rule, where one lawyer speaks for each side, I would like to propose that once you rule, that we leave it at that, and that we don't continue to re-argue these motions, that you rule, and the lawyer for each side, both sides, will then sit down. I'd like to offer that to the prosecution.
Thank you, counsel. All right, any other issue? All I see left is the videotape issue regarding opening statements, then the court's pre-instructions and opening statements.
We need to address the court objections that we have to those exhibits, those few exhibits we were shown by the defense on Friday.
All right, Ms. Clark, why don't you use the podium?
Because I'm trying to stay off camera. You asked me why I'm not, so. With respect to the photograph, the defense proposed to use a photograph of Claudia Ratcliffe standing near the bodies. Is that withdrawn as well? There were some stills that defense indicated they withdrew. I don't know if this is one of them.
Those were,
Just the police officer walking down.
Okay, so not the one with Claudia Ratcliffe.
Not
Okay. So there'll be objection to that one.
That is what? A photograph of what?
Of Claudine Ratcliffe standing near the bodies.
And who is Claudine Ratcliffe?
I'm sorry, Your Honor. She's a coroner's investigator.
Was she the young lady depicted in the videotape
She
that we
was.
just saw?
She was.
All right, and what's the basis for your objection to the photograph of Miss Ratcliffe by the body?
We would object that it's irrelevant and ask for an offer of proof.
Well, counsel, this is opening statement.
I
What
understand.
what does the photograph depict? Do we have that available for the court to look at?
The court saw the photograph. It's the photograph of the woman from the coroner's office standing in her shoes with gloves on top of Mr. Goldman's jeans.
I might address the court. To save time, Your Honor, I will withdraw the request to use the videotape during the opening statement. I was indicating to the prosecution that I now understand from talking to my office that there's a good likelihood it is in San Francisco. It won't be here until later this afternoon. And rather than delay these proceedings, so we can proceed, we'll cross that bridge. I'll make it available to them, and they know we have it. They'll have a copy, and then we'll deal with it in evidence.
All right. Thank you, Mr. Cochran. Sure. All right, then, counsel, that leaves only the instructions to proceed with for opening statements.
I haven't addressed our objections to the exhibits we were shown on Friday, and then we have objections to the board, all of the about 20 boards that they produced
Do you have
for the first
objections
time
to
today.
all of these?
Not on all of them, no.
All right.
So
What are your
we-
objections?
With respect to, I'm prepared right now to address what we object to with respect to the exhibit shown us on Friday, and that is the picture of the defendant and Sidney at the recital on June the 12th.
What's the basis of that objection?
We would have no objection to a depiction of the defendant alone, but we think that depicting him with Sidney is irrelevant, and under 352, we would ask that the court limit the presentation of the photograph to just the defendant. We can see how the defendant's depiction may be relevant, but that would be all.
All right. What else are you objecting to?
Defendant's calendar pages, January to June, January to May has no relevance to these proceedings.
What else?
The rest, we have to address what we see in the boards.
All right. Which one of the boards?
May I have a moment, Your Honor?
Sure. I thought these were objections to these boards here. I thought that's what we're dealing with.
Yes, Your Honor. We've just, for the first time, seen them this morning. I had 5 minutes to look at them during a break in the proceedings. And we want me to
Well-
confer for a moment to present our objections because they were just presented to us.
Well, counsel, they've been here all day. They were here all through the lunch hour. I've had the opportunity to look through them all. I mean, can we do this, just go through them one at a time, see if you object to it? Please?
Yes.
All right. Number one, top board. All right, where's the easel that you're going to use to present these things, Mr. Douglas?
I'm sorry, Your Honor.
Where is the easel that you were going to use to present these things?
We have a couple over there, Your Honor. We have two more over here.
All right, set one up so I can see these things.
Very well.
Madam Reporter, do you want to switch?
not,
Mr. Douglas did tell one, let's talk about it, and we just delivered this afternoon.
I was just told about it this morning, I've never seen it.
All right, let's start with this one.
We'd like to know what the relevance of this could possibly be.
All right, this appears to be a large blow-up color photograph, appears to be of Mr. Simpson and 4 other individuals. What's the relevance of this?
This is Mr. Simpson. This photograph of the evidence, Carol Connor, this photograph was taken on Saturday evening, June 11th, affair just prior. There'll be a lot of evidence by the prosecution about Mr. Simpson and things he was doing on or around the 11th and the 12th. This is an affair, without going into detail regarding the offer of proof. This is where it was the night before, documented evidence, documented who he was with, and the people who he was with. This photograph was just obtained today, blown up now, and brought to court. We advised Ms. Clark about it, found out this morning, and then we're now, as an officer of this court, I will link this up along with the other evidence. Make it up to relevant issues, as I understand.
All right. Next are the aerial photographs.
The aerial photograph drawing is an issue of representativeness. It's clear that there are tarps on the gates, and we know that those were not placed on those gates until sometime after the events in question. And there is an issue of substantial change in circumstances as to whether this is representative of the conditions that were in existence at the time of the murders.
I think that counsel is explaining needlessly, there's been no substantial change, and I think again, the evidence which he talks about deals with, it seems to me, weight, if anything, got admissibility. These are aerial shots. They have their own aerial shots. We're going to be as accurate as we can in the presentation of this evidence. That's the situation.
All right, Mr. Cochran, do you know when those aerial shots were taken?
I'll have to give me just a second.
All right, next.
The gates are not changed? These tarps are not up.
All right, second aerial.
Is that the same picture?
All right, counsel, what I need is one person to present the photo, and Ms. Clark, once you step back, we need to make a record. Court reporter can't hear you talking to the exhibits. Once you step back to your counsel table, perhaps we could have Mr. Douglas pull these up. Why don't you turn the easel around? Ms. Clark, why don't you step back, please? Why don't you turn the easel around, Mr. Douglas, so that counsel can see it, I can see it. Perfect.
This next board, Your Honor.
All right, SOC timeline.
Correct.
Ms. Clark.
The chart is after June 13th, 24th, and 29th, there's at the bottom of the chart indication no blood was found. That assumes that they were looking for blood on those dates. They were not. The evidence will show that there was no examination for blood.
That's a question of fact, Your Honor, going more to the weight of the testimony rather than to the admissibility of the board.
Well, actually, it goes beyond that. It does go to admissibility when they are attempting to assert something for which they're. It would be one thing if there was some indication that they were submitted for serological testing, and then it would be an issue. But there was none. And counsel's aware of it in discovery. There was no attempt to look for blood until August 4th. So saying that there was no blood found attempts to infer something that there could be no predicate for, there could be no foundation for.
Your
That
Honor,
is, that there was a search for.
the socks which were located at the foot of the bed in Mr. Simpson's bedroom were examined on the 13th, were examined by criminalists along with Doctors Batten and Wolf, and were examined for a third time on the 29th. There was never any notations on any of the documents as to the presence of blood on those socks until the 4th of August, and that is what's reflected on the chart. Those are true statements. They can be spun on cross-examination or on redirect, however they choose to spin them, but the board is accurate.
The problem is misleading the jury, Your Honor. They're trying to get the jury to infer that there was a search for blood that came up with none. That never occurred. If there was no search, then of course there was no blood found, but that doesn't prove anything. If you haven't looked, of course you're not going to find, and that's misleading.
All right, next item.
Your Honor raised a question as to the time of the taking the aerial photographs.
Yes,
I took them in early August.
thank you.
This was a photograph, Your Honor, of Mr. Simpson and his daughter Sydney at the recital. There was suggestions made in various offers of proof during the domestic discord and other hearings that Mr. Simpson never was able to see his daughter, and in fact was never able to present the flowers to her. This is going to be a photograph contradicting that directly.
Ms. Clark? I think you've already made your objection to that photograph.
I think I have an additional statement to make about it, now that I hear counsel's offer of proof. If I may.
Sure.
Counsel's offer of proof makes it clear that this is irrelevant. We are never going to, we're going to, the opposite actually, we're going to establish through evidence that he did see his daughter, he did give her flowers, there was contact. We're going to establish that through more than one witness.
All right, next
So
matter.
there's no issue that requires that photograph to be shown.
This is another board, Your Honor, which we will contend reflects the amount of blood that was taken from Mr. Simpson and placed in a blood vial. It will account as best as our records can confirm the occasions when blood was removed, and it will suggest, as far as our records concern, and what we intend to offer to the jury, that there is blood unaccounted for.
And by this, yeah,
Yes?
and by this board, counsel is attempting to argue that 2.6 milliliters is unaccounted for, or 0.8 is unaccounted for. I'm sorry, 1.8? I find it a confusing display then, because it seems to indicate that 2. I don't know, it's hard to, but that's not.
That's not a question of whether
No.
this board is under the condition, Your Honor. If she can't understand it, she'll listen to the opening statement, and she'll understand it clearly.
Maybe. The problem that I have, Your Honor, is that I don't want I think it's important that the jury not confuse this, but there are assertions there. The problem is, Your Honor, that we have assertions of precision with respect to those numbers that is untrue. I believe that what all of the experts have stated in their reports is they have been very clear that the amount used was approximate, was just about. And with respect to the assertion of 8 milliliters, that isn't borne out by the testimony either. The nurse then apparatus who took the blood indicated that he was unsure of precisely how much in his testimony. He's not aware. He thinks he filled the tube up. He couldn't give a precise number as to how much he took. He gave an estimated range, I believe. And so counsel's charge is misleading and derogation of the facts.
Your Honor, the witness testified that the amount of blood he collected was between 7.9 and 8.1. We are trial lawyers, and we certainly understand that if we make representations that we are not able to support, we do it at our own peril. That is not a question of relevance or admissibility of this board. That is a question that they will seek to contradict in trial.
Ms. Clark, where is it in the, do you know offhand where in the preliminary hearing transcript we have that testimony regarding how much blood was taken?
I'm located right now, Your Honor. Thank
Ms. Clark, you don't object to this board.
you. Right, no objection to the board.
Thank you. Thank you. Thank you. A map of Los Angeles.
I find it highly prejudicial, but no.
All right.
Right, no objection?
You don't object to the American Airlines Board.
No objection?
This is a board, Your Honor, entitled The Bronco Timeline. What we again are seeking to display by this board, which will be narrated by Mr. Cochran during his opening statement, is our belief that certain things occurred on certain dates as it concerns the Bronco. Whether there is a dispute factually that something did or did not occur on the dates alleged will be questions for the jury to ultimately decide.
Ms. Clark?
Or the other. There are several calendars, Your Honor, from January 1994 to June 1994. We understand our obligation to properly authenticate and lay the proper foundation for its introduction. We believe in good faith that we will provide the necessary link-up to justify the admissibility of each of these documents, and that is why it's displayed on boards. They will also be shown on an overhead as well.
Ms. Clark?
That was an offer of proof. I thought that counsel was going to make an offer of proof.
What's the relevance of these items?
Because, Your Honor, they are very relevant to show a certain course of conduct inconsistent with certain suggestions that Mr. Simpson is a stalker, that Mr. Simpson had certain preoccupations, and this will be very important to dispel for once and for all that particular notion in the weeks and the months leading to June the 12th. They've had this calendar for months.
Is this Mr. Simpson's handwriting on this calendar?
It's Kathy Randish, Your Honor, who is a witness on both individuals' witness lists.
Kathy Randa being his personal assistant who maintains his records and calendar.
For the last 20 years, she has, Your Honor, yes.
Your Honor, that is a reproduction that is not the original, as I understand it. Kathy Randa admitted that that's a reproduction that she created. So we have issues of authenticity. Furthermore, it's been the defense contention all along that this is irrelevant. Mr. Ullman has repeatedly so argued that this is irrelevant, that this whole calendar is irrelevant. And
Well, what is your argument regarding that this is a reproduction, quote unquote?
well, this was something that was recently created, not created at the time. So it's going to be very difficult for counsel to establish the authenticity of this document, let alone its relevance, given the fact that we have the statement of the witness who recreated it, that she was the one who created it and that she found in possession of the original.
It's my understanding, Your Honor, that Mr. Shapiro turned over the original to Mr. Darden. The people have the original themselves.
Mr. Darden, breaking my own rule.
Thank you, Your Honor.
You're welcome. Good afternoon, counsel.
Good afternoon, Your Honor. Your Honor, in the grand jury, Kathy Randa testified that she had given the original calendar to an attorney for Mr. Simpson, and that she then went about creating or recreating a second calendar. And that second calendar was seized from Mr. Simpson's office pursuant to a search warrant. This is the recreation. I do believe that that either the prosecution or Judge Zuliger has the original calendar, but this is not the original calendar, and it is not accurate. It is not an accurate recreation of the original calendar. But still, there's the issue of relevancy, and I don't see it.
Mr. Douglas, I'm concerned that this is not the original.
Could you hear from Mr. Shapiro, would you, since you broke the rule that one time? Shapiro,
Well, since Mr. Shapiro is the one who actually had custody of the document in question, Mr. Shapiro, good afternoon.
Yes, Your Honor, I was served a subpoena to produce the original documents. I called Mr. Darden on the phone. I told him I didn't have them, but I would attempt to locate them. In the meantime, reproductions had been made of the original, which I told him I had and which he told me he had. At that point in time, Attorney Mel Sachs delivered to me under seal the original diary. I brought it to Your Honor under seal because I did not think it was proper for Mr. Darden, who was then ostensibly in charge of the Al Cowlings investigation and who was operating under some type of wall of separation, to have this. Your Honor then directed me to take the matter up with Judge Zuliger, which I did. Judge Zuliger took custody of it and turned it over to Mr. Darden and sent me a notice that he had done so.
That still isn't the original calendar. The original calendar has other notations regarding birthdays and things and girls' names and stuff like that, and this isn't it.
Your Honor, first of all, this is the opening statement. And again, if there are areas that Mr. Darden has witnesses to that this calendar is incorrect and does not properly depict Mr. Simpson's schedule in the months of January through June, that's something that can be brought up. I think a simple question can be asked whether or not a calendar was turned over by me to Judge Zuliger, and if Judge Zuliger released that calendar to Mr. Darden, and if in fact that is a photocopy of a calendar or an original of a calendar, and we should put this matter to rest.
Mr. Darden?
That is not a photocopy of the original calendar. And as far as authentication is concerned, the last time I saw Kathy Randa, she was taking the fifth. And so I don't know how counsel intends to authenticate any of the calendars at this point, actually.
All right, does the prosecution have in its possession the original or an original calendar similar to this?
Either we have it or Judge Zuliger has it.
That was the simple question, Your Honor. No,
I said
Wait,
I'm not going to argue with him. Thank you. That's the answer. That's the question we needed to ask.
And that is not a copy of the original.
Oh, no, Mr. Darden, the question is, who has the original diary? Where is it?
Either we have it or Judge Zuliger has it. Okay? And if we have it, I'm sure someone is upstairs now looking for it. So bring it down, fellas, if it's there. Okay? And we can resolve that issue, but there's still the issue of relevancy. But that isn't a copy of the original calendar.
Okay.
Your Honor, the remaining boards, there is a legend for our timeline to which there's no objection. There are then jury instructions to which I do not believe there is an objection. One on credibility of witnesses.
With respect to the jury instructions, Your Honor, there will be no objection provided you can read what next year they are not altered.
They've been consistent with the court's ruling, if you like.
I just want a chance to read it. If that's all right.
All right, credibility of witnesses, standard 220. Counsel, I think we'll move on. You'll have the opportunity to compare it. Assuming the text to be accurate, do you have any objection? All right.
The next is presumption of innocence, burden of proof, reasonable doubt, with the moral certainty language stricken. The next is alibi. Last one, Your Honor, is sufficiency of evidence generally, or sufficiency of circumstantial evidence generally.
All right, any objections to that? No, there's a second page that goes on to talk about 2.01, sufficiency of circumstantial evidence, direct and circumstantial evidence. That's page 2. That's 2.01, counsel. All right, any other comment, Ms. Clark?
With respect to the credibility of witnesses, Your Honor, the board proffered by counsel doesn't conform to the alterations requested by the court.
What does it include that I struck?
I believe oral affirmation.
That's a detail that's inconsequential at this point. We may have witnesses who may testify under affirmation. All right, are the matters submitted?
Yes, Your Honor.
You wanted some information on the issue of blood, or how much blood the nurse took. You wanted the prelim transcript page numbers?
Yes.
Your Honor, there's one other chart that we provided a hard copy for. Derelictions, distortions, and deceptions. She has a hard copy of it, and I don't believe that there's an objection. I'm not sure.
Ms. Clark?
I do not believe there is.
There's no objection to it? Sure.
Does Mr. Darden have the original calendar from upstairs that he can compare our charts with?
I'm sorry.
I don't know. We need to finish the first issue about the derelictions, et cetera, exhibit.
No objection.
All right.
I wondered whether Mr. Darden was able to compare the original copy, or the original of the calendar, to the boards that are presented.
Mr. Darden, do you now have a photocopy of that now?
I have a photocopy of the calendar. Can't see
All right, counsel, let me make it easy for you then. All right, is the matter submitted?
Yes, Your Honor.
Submitted
I'm sorry, I'm what?
on all your objections?
No, Your Honor, we're not. No, we had, with respect to the calendar issue, I think Mr. Jordan has something to add. With respect to the derelictions issue, let me withdraw my no objection position and simply state that we would object that it's argumentative. It's not an opening statement exhibit. It's an argument exhibit.
All right, I haven't seen it yet. Where is it?
We would ask the clerk.
It was faxed over here and we gave the copy.
I don't
for
know.
bunch of stuff. We don't have a copy of that.
Yes, let me look through my stuff. In the meantime, let me give the court the pages of the nurse's testimony.
All right.
At the preliminary hearing, the matter was addressed on page 25.
What volume?
Um, I'm getting that. And in the grand jury,
20, well, I need the volume in the preliminary hearing. And would you have Ms. Scalinas find that for me, please?
you get one.
Oh, I'm sorry. Ms. Clark, what was the name of the witness? What was the name of the witness?
Donna, T-H-A-N-O, Paratus.
Paratus.
P-A-R-A-T-I-S. And I'm sorry, did you want the grand jury or not?
Yes, please.
Page 271.
All right, do you have that handy so you can tell me what that is?
I have both of them, would you like them?
Please.
Your Honor, I believe that the issue was raised more than one time in the prelim. If the court would allow, before finally ruling on that particular chart, I'd ask the court to allow counsel overnight to return to the office and obtain our site so that we could adequately give it to the
All
court.
right, counsel, let me give you my temporal prognostication at this point. It appears to me we will not get to opening statements today because I intend to pre-instruct, which will take approximately half an hour. It's also going to take us 20 minutes to get the jury down here physically. So I don't see us actually launching into opening statements today. So, counsel, at this point, I'm willing to take under submission the argument regarding the exhibit with the blood samples, and I'm ready to rule on the other objections. Any other comment? All right, as to the photograph of Nancy Radcliffe, the objection is overruled. As to the photograph of Mr. Simpson and his daughter Sydney at the recital, the objection is overruled. At the, as to the calendar, January through June, the objection is sustained. Pending is, that's a tentative ruling. Counsel can compare the original with what's there to see if there are any material discrepancies. But since these exhibits are not the original and are recreations, the objection is sustained. As to the aerial photographs, the objection is overruled. As to the SOC timeline, the objection will be sustained. The no blood found language is argumentative and assumes facts that are not in evidence. And as I indicated, the court will rule tomorrow morning on the blood sample issue once counsel have isolated the transcript that's relevant.
Your Honor, with respect to the SOC timeline,
Yes.
and the court had some concern of the language, no blood found.
If you delete that language, then it's not, then it's an accurate statement of what's going on.
What about if we were to put no blood observed?
How about if you cover it up completely?
Very well, Your Honor, we'll do that. I'm reminded by Mr. Scheck, Your Honor, that there is a document, an official report, that says no blood observed. Could we show that to you tomorrow to perhaps persuade the court that it would be proper and accurate to have that language?
As to that one point in time?
Correct, Your Honor. Thank you.
All right. Because obviously we won't get to these things today.
With regard to the calendar, Your Honor, the court would allow us an opportunity for we need to compare with Mr. Gardner.
Yes.
Mr. Gardner, I can sit here with each.
Yes, but let's not do that now, counsel. All right. All right. Ms. Clark?
I don't know, this
Okay. Well, counsel, at this point, I hate to ask this question, I shouldn't ask. You're right. All right, counsel, the court is going to stand in recess then for 20 minutes. I will direct the sheriff's bailiffs to bring the jury down. I'm going to pre-instruct, as I indicated, and then at that time, we will recess for the day and begin opening statements by the people promptly at 9 o'clock tomorrow morning. No, I take that back, because they still have to rule on some of these gizmo problems we have here, 10 o'clock with the jury. Because I figure this is probably 15 minutes worth of arguing, so knowing this group, it's probably an hour. All right? All right, let's take 20 minutes, let's bring the jury down, please.